It's Rick. It is August 8th, 2019. If you're interested in receiving my paperwork to challenge child support, my email is rick, R-I-C-K 0327 at me.com. The email address will be in the description. Also, the paperwork is in exchange for a gift that you will send. Okay? Uh, Understand that the information you're seeing in my video, I encourage all of you to double check. Okay? I'm a pretty good researcher and looking up information, but hey, I can make a mistake. I've made them in the past. I can make them again. Plus, I'd be more comfortable knowing that you guys checked it. Also, it's good practice as well. Okay? All your answers are on the computer. All you have to do is use Google. Google Scholar has all the citations from. You have an option in Google Scholar that you can just look up the case laws in your state, or you can use it, just look up the Supreme Court. It's really not hard to do. Okay, it's free. That's the best part. A lot of these sites like Westlaw, um, Heinlein Online, they're expensive. Okay, there are a lot of annotated statutes that they don't want you to see. That's not publicized, and it's just for the lawyers. The lawyers do not want people like you and I going into court and challenging the jurisdiction of the court, citing case laws, citing statutes and codes that they use, asserting your sovereignty. That's the big one they hate. They did a good job, and I don't know this for a fact, but just because I'm a researcher and I've been on the computer for about 7 years now, I have a pretty good idea what's going on in the world. I have a pretty good idea who's real and who's fake. They had this group called the Sovereign Citizen Group, which was probably started by the government because they don't want people coming into court asserting their rights and asserting their sovereignty. And they acted like morons in court, started threatening people. And, when you start threatening people, then the FBI puts you on the list. Now, I'll give you a great example. I'm not sure if any of you are knowledgeable with this QAnon thing on the internet. It's a message board. It's an anonymous message board. And QAnon, it's supposed to be somebody high up in the Trump administration who's feeding information to everybody on the message board of things to look for, things that will happen, things that have happened, what to look for, and they've pretty much been spot on. So what the CIA did in the 60s, when people were like citizen journalists, there is no law. Just like going into court, you don't need a license to be proficient in law. They want you to think that. Lawyers go to school. They claim they're licensed. They're not licensed. That's nonsense. They have bar memberships. That's all it is. It's really they're a part of a club, and they don't want you or I in it. Anyway, citizen journalists were investigating the JFK assassination. They started asking questions why, I'm just paraphrasing here, but 19 of the eyewitnesses of the JFK assassinations all ended up dead in a 3 or 4 year period, whether by accident or, death or whatever. But the odds of that happening are astronomical. So they had to come up with a phrase to basically disqualify the findings by calling, what's the best way to do it? By calling somebody crazy. So they called them conspiracy theorists. Well, in courts, they have their own conspiracy theorists. They're called sovereign citizens. And on the FBI website, and I think the Department of Justice as well, well, they call sovereign citizens domestic terrorists, which is nonsense. I could tell you personally, because I sued a couple of state people 4 years ago, that the first thing that they claimed was their sovereignty when I sued them under the 11th Amendment. So if state employees are allowed to assert their sovereignty, why cannot you and I? So what they do is, whenever you assert your sovereignty, they call it an ideology. They claim it's not true because the sovereign people, what it is that when you're a state citizen, you're sovereign from federal laws. Well, think about it. You're not in federal property. You're not in Washington D.C. You can only be sued by a private person. So if I harm somebody else, that person can bring me to court, and if they're able to show causation of an injury that I caused, injury in fact, they can sue me for damages. And I'm simplifying this, of course. And like all these rules of the road, what you don't realize is when you get a driver's license and you sign your name, you are agreeing to the rules of the road, traffic laws, vehicle traffic laws. That's the reason why when you go to these courts, you're not really allowed to assert your constitutional rights, because you basically sign them away. But you were tricked, you were deceived. Were you knowingly waiving your rights? See, that's the thing. You have to knowingly waive your rights. That's where the Miranda warning came in. You have the right to remain silent. Anything you say, may and can be, will be used against you, and blah, blah, blah. I should have it memorized. I must have said it over 100 times in my career, but I don't even think about that anymore. But anyway, they're supposed to do that for you in these proceedings. And I'm going to show you that in the slides today. Okay? So the point I'm making is that they don't like us coming into court. They'll look for any reason to disqualify us. Well, in this video, I'm going to show you how we can disqualify them. Okay? The more you know, the better it is you can defend yourself. You have to be confident. Okay? You have to knowingly waive your constitutional rights, your state and the United States Constitution. You cannot be tricked, deceived, or when they misrepresent a fact or evidence, it is a violation of due process. Okay? All right, so in this video, I'm going to show you how we're going to use, when we came to this country from England, we brought over the laws and the customs. Well, they decided in court cases that we're still allowed to do that. And one of them, and what they are, some of our writs, writ of mandamus, right? Writ of habeas corpus, writ of certiorari, which is a judicial review, writ of prohibition, which is prohibiting an action. So we're going to use a writ of Quo Warranto to challenge the jurisdiction of the court and challenge the authority of the presiding officer, which is usually a judge surrogate. I call them fake judges. Now just look at the name, judge surrogate. A surrogate is a stand-in. So if you have a judge surrogate, what you have is somebody who is not a judicial official. Therefore, they cannot yield a judgment. And I'm going to show you a Supreme Court case that said this. Therefore, anytime you are in front of a judge surrogate, unless they have your knowing consent, which is called informed consent, it's informed meaning they are properly informing you without any trickery, without any deception, without misrepresenting anything, what you're giving up or what you're consenting to and what you're giving up. They're supposed to help you on the judicial codes. And your attorney's supposed to help you, but they do not. So these are all the tricks and the deception. Okay, so let's move on with the slides. Okay, so the first slide is the challenge jurisdiction and authority of judge or fake judge by filing a writ of quo warranto. You have to file it right away. Okay, I know there are case laws out there that say you could challenge jurisdiction at any time, blah, 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 in any court. I'm just giving you the facts because I've been in court. Everything that I tell you to do, I've done, or I know somebody that's done it. What's great about this channel and my subscribers and the people who have taken, who's received my paperwork, I interact with them. They give me updates on what's going on with their case. So I know what's being done out there. I know what they're doing. I know what they're going to say. So that's why my paperwork is always changing. Okay, I try to change with the times, as they say. I evolve. Okay. Earlier in the video, I mentioned the sovereignty stuff. So I'm going to recommend to you, if you're not comfortable, if you see anything with sovereignty in my paperwork, remove it. You can just be a state citizen. You don't have to be a sovereign state citizen. Okay? You can assert your sovereignty just by using the words. I describe it that way. And in my footnotes, in my paperwork. Okay? So if you're not comfortable with it, remove it. Once I send you the paperwork, it's your paperwork. If I suggest you leave a lot of this stuff in there, but some of you, many of you, I have a lot of subscribers that are very talented, very smart people, very educated in what they do, and I've had many people be successful by taking my paperwork and it's like a menu, and then they add their ingredients. Okay, you could do that. I just suggest don't change things because you watched it on another channel, unless you know for a fact. Like Amin Osiris, you guys know, he's my friend. He's got excellent information. So he's not one of those people. Out in California, you got Fifi, it's me. She got excellent information. She's a very good researcher. But there are a lot of channels out there that are just doing this either because they're trolls, they're looking to make money, or they got big egos, or they have an ego. I started this channel because I was a victim, and I just wanted to document it. I had no idea this was going to happen. I had no idea that I was going to end up with over 12,000 subscribers one day and helping thousands of people. Okay, what I do is I give you the facts and I give you hope because I did it. Okay, because I went into court, was knowledgeable, and I had a background because I sued them and I was stonewalled, but my stuff was right on point and they know it or knew it. Okay. So let me move forward. I always do these little tangents and I apologize. Okay, so you just read these case laws here. But here's where it says, not only must the challenge authority of a judge or prosecutor be timely, but it also must be brought by a direct quo warranto proceeding. Ordinarily, this should be presented in a circuit court. A circuit court is a lower court. So that's what I'm saying, why you should do it immediately. Okay? A quo warranto is a prerogative writ by which the government can call upon any person to show by what warrant he holds a public office. All right? So you're allowed to challenge, you're allowed to ask for the oath of office because of public offices. So you're allowed to say, I need to see your credentials. How do I know you are who you claim to be? That's why they're supposed to have an oath of office. Listen, I just told you a judge surrogate is a fake judge. Okay, so it's like that's the best example I can give you. Also, by doing that, by asking them for their oath of office, say, well, if you were a real judge, you'd have an oath of office. All right? Are you a real judge? Then where's your oath of office? You're make-believe. You're fake. You have no authority unless I give it to you. Unless I consent, and I am not consenting. Okay? This is the case law. Johnson. What the F is it? Johnson versus Florida. Okay? That's it right there. Where challenges to authority of the prosecuting authority or presiding, while not commonplace. So this is what they're saying about the writ of quo warranto. See, while not commonplace, meaning that not everybody does it, but they are not unknown. It's been done before. Right? Here's the case law. So that's the reason why you're allowed to do it. And they can't legislate it away. They claim they can, but they cannot. All right? Because there's a case law out there that says, and I opened up the video with it by saying that when we came here from England, we brought over these customs and usages and law. Okay? So the defendant argued that the trial was null and void because the assistant solicitor was not authorized to sign. It's like also an assistant clerk is not allowed to sign paperwork either. So this argument was first raised in a motion to vacate the judgment with the trial court, and the denial of that motion was part of the direct appeal. The Supreme Court concluded that the defendant waived his argument because he failed to raise it before the judgment. So in other words, he didn't raise it until after, in other words, the judgment was already issued. So that's the point I'm making. Now you can't always, as they claim, you could challenge it at any time. I'm just telling you that they're not going to let you. Okay? That's why you're better off doing it in the beginning. Okay? Neither the common law or our statutes favor the policy of a defendant in waiting until the last stage. You understand? That's the reason why I don't want you to wait till last minute. And common law. So in other words, you got to do it right away. You can't do it a year later, 2 years later. Okay? I'm just telling you. And here's a case law to show it. All right. I'm going to show you that. All right. So, challenging jurisdiction, challenging authority of a judge surrogate by writ of quo warranto. So while you're doing a writ of quo warranto, you're also going to challenge the authority of a judge. And you're going to challenge the jurisdiction of the court. All right? So what I like to do is I like to challenge the jurisdiction of the court because they have to show proof that you consented, that you knowingly consented. The State Uniform Interstate Family Support Act under Article 2, Section 201, basis for jurisdiction over, here's the key word, non-resident. Well, if you're living in a state, you are not a non-resident. You are not a stranger. So that's the key. You have to waive it. That means they have no jurisdiction over you. See, all of these uniform interceded keyword there, interstate, these were made so they can get somebody from another state in another state. That's it. Federal law, interstate commerce. But if you're a state resident domiciled within the borders of that state, you are not a non-resident. You are not a non-domicile. You are a state citizen, and your state constitution protects you, your state sovereignty. Okay? Famous case is the Burnham case I cite all the time, Burnham versus Superior Court. That's a case where they stated that a person, not a judge, it's called quorum non judice. Person, not a judge, cannot yield the judgment because the judicial authority was not present. And that case was in 1990, but as recently as 2011, the Supreme Court cited it. It was cited for personal jurisdiction, but it doesn't matter. Everything stated in the opinion becomes an adjudicated fact. The Supreme Court is a court of last resort. So that means that's it. Once they make a decision or opinion, it's final, it becomes Supreme Court law, and all states are supposed to comply. Hence, Roe versus Wade, the abortion law. Okay? That's why a state cannot say that a woman cannot get an abortion, because the Supreme Court says she's allowed to do whatever she wants with her body, basically. Roe versus Wade. Okay? So right here, it says that you have to submit to the jurisdiction of the state by consent in a record, by entering a general appearance, or by filing a responsive document having the effect of waiving any contest to personal jurisdiction. That's why my paperwork, we do that. Okay, just had a guy, Victorious, Jason. Hey, Rick, just want to let you know that we won the case. Not sure if the paperwork that I submitted worked, but it did, trust me. The magistrate said he had reason to believe, and the evidence she submitted was incredible. And for some reason, I can't get this whole thing squeezed in there. I don't know why. But anyway, the case was dismissed because he submitted the paperwork challenging personal jurisdiction, stating that she didn't offer any evidence. And the case was dismissed. See? So he's victorious. So it just shows my paperwork does work. Not guaranteed. I don't make any guarantees. So like any of these assholes out there, these jerk-offs that, badmouth my channel, they're nothing but trolls. Because one, you never hear me bragging about my paperwork always works. Okay? Because I know they don't. We're dealing with some very bad people. The courts are very, very bad. All right? They destroyed my life. My life is great now. But it wasn't 5 years ago. Okay? And but I could tell you, I know all of you. I know the heartache and the stress that you're dealing with right now. Trust me, I do. I used to do all the videos when I was in my car ranting and raving. I know all about it. Okay? That's the reason why I do these videos. I give you free information. I try and arm you with as much information as possible to go in there and to fight these people. Not fighting like this, fighting with this, and paperwork. By submitting paperwork, you're submitting written testimony, and it's a record. And I'm going to show you in this video that the Article 1, Section 10 of the United States Constitution, the obligation of contract clause requires that they respond to your paperwork in writing, because it's written testimony. You don't have to speak. I prefer to my paperwork is my testimony. That's it. That's all you got to say. I submitted paperwork the paperwork was dismissed. They're famous for dismiss. Oh, yeah, it's dismissed. No, objection. I want a written response so I can see the facts and evidence. Or I want to see you clarify your facts and evidence that gave you the jurisdiction to dismiss my paperwork. Am I not presumed innocent until proven guilty? No? Well, then this is unconstitutional, whole proceedings. And you're disqualified. Okay, I'm just giving you an example. Okay? While we're doing this, another one, court case. This guy they were threatening to throw in the jail. Submitted my paperwork, and my husband barely had to say the thing. The case was adjourned to October 1st. Is there any way? And I helped her with that. Okay? So this guy they were threatening to throw in jail. And now he went to court and he didn't say anything, and they adjourned it till October 1st. Not bad. I've read almost every affidavit, and Rick, I love it, love it, love it. Thanks again. I don't get any bad response from my paperwork. A couple of knuckleheads I have, because they're scam artists. They want to put in a claim with with PayPal so they can get their money back. But you can't do that with me anymore, because I've been using them for a while, and I had somebody do it, and PayPal right away dismissed the claim because of my record. Because I'm very, very honest. And I don't ask for a lot of money for the gift because, again, I can't make any guarantees. And I know you guys are financially hurting. But trust me when I tell you, you're getting a lot of great information and great paperwork that I can easily get 5-10 times the amount of money I ask. Okay? All right. Let me move forward. Stop yapping. Okay? All right, so therefore you are demanding the court. Oh, wait. Here's the thing about the consent. See, this here is a scam. Submitting jurisdiction by entering a general appearance or by filing. What they're saying is when you respond, you're giving them consent. But you're not knowingly giving them consent. You have no idea by defending yourself that you're giving them consent. You have no idea by showing up that you're giving them consent. That's what they claim. That's how these people are really messed up. So what they do is they send you this threatening document. If you don't show up, you may be arrested. Your license may be, but people don't know that the word may or shall doesn't mean it's going to happen. But so it's a trick. So, right? So what you could say is the undersigned requires evidence that the undersigned knowingly submitted to the jurisdiction of the state. And the Supreme Court has stated, it is a well-established rule that a consent search is unreasonable under the Fourth Amendment if consent was induced by deceit, trickery, or misrepresentation. I got news for you. That also, because you guys know I'm a retired police officer, a cop cannot ask you to search your car just because. He has to have a reason. He has to have a reason to ask the question. Forget about if you're scared and you consent. A good lawyer will say, officer, do you ask every person you pull over, can you search the car? Do you ask elderly people if you can search the car? You understand? That's but they get away with it because most people don't know their rights. Well, that goes with this as well. Okay, so therefore you are demanding the court to provide proof that you submitted to the jurisdiction of court, because it says right in the Uniform Interstate Family Support Act that you must submit to the jurisdiction and consent. Okay? That's the case law. And this was an internal, an IRS case, but it still applies. You don't just, you just remove that part. See, this applies to everything. So they can't say, oh, that was an IRS case. No, it's not. It's a Fourth Amendment case. All right? And by the way, I'm not one of these tax protesters or anything like that. That's something that if you want to do that, go right ahead. Just don't ask me for help. All right? I had my fun with child support, and it wasn't fun. So I don't want any problems with the IRS. Trust me. I've had people ask me, I'm like, listen, dude, I have nothing to do with those people. I just suggest you do what they tell you to do. I mean, I'm just telling you, I'm a believer in ducking a punch. All right, if you want to be one of these people going around, driving around, messing with cops and that, all right, you're going to get your lumps. You understand? There are people that go out there and do that. I'm just not one of those people. All right, I like to live my life peaceful. If somebody messes with me, I'll fight, of course. But I'm not going to go out there looking. Okay? All right, so we're going to challenge the authority of the presiding officer by demanding a copy of the oath of office. All judges and fake, it's really Judge Circuit, but I'm letting you guys know they're fake, are required under state constitutional law for a public officer law and under the United States Code 28 U.S.C. Section 453 to have an oath of office. Knowing these laws are a great way to disqualify a judge and fake judge surrogates. You could say, are you a real judge? Please show me on the record your oath of office, as you are required under 28 U.S.C. Or look up under your state constitution, public officer section of the state constitution. Or just Google public officer laws. Your refusal to show your oath of office raises questions of your ability to remain impartial. So if they don't show you an oath of office, you're questioning if they're impartial, if they're qualified, if they have the authority. That's enough to disqualify. And you go file paperwork. So again, this is a great way of challenging jurisdiction. This is the code right here. You guys can read it. All right, I said before, obligation of contracts require courts to answer writ of quo warranto. So they're required to respond, and no state shall enter into any treaty, alliance, or confederation, grant letters of marque, and appraisal, coin money, blah, 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 make anything but go, blah, 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 pass any bill of attainder, which is child support is bill of attainder, but that's, I've mentioned that in the past. A bill of attainder is when they focus on just one group of people, and they're presumed guilty and they're punished. So the child support is obligors. They make fathers, they don't even call you a father, they don't call you a parent, they don't call you a man, they don't call you a woman, they call you an obligor. They're changing your status. And in the past, I told you guys, you can't be an obligor unless you have proof of a contract. And remember, they need your consent to contract with them. Okay, that's another thing. Where's my consent? I didn't waive my constitutional rights. Show me where I knowingly waive my rights. Okay? So they cannot pass any law impairing the obligation of contracts. So they can't say, well, I don't have to respond to a writ of quo warranto citing some, statute or procedure. They can't. And all you got to do is cite Article 1, Section 10 of the Constitution. All right? Practices of law by justices and judges. Judges and fake judge surrogates are practicing law from the bench, which is a misdemeanor under right here for 28 U.S.C. 454. Anytime a judge or fake is writing an order without a trial by jury, they are practicing law from the bench. You're only supposed to be judged by your peers. For any controversy of $20 or more, you're entitled to a trial by jury. That has not changed. And as recently as 2018, they cited the case Murray's versus Hoboken. I'll show you. I used to talk about this all the time. Anytime they enter a plea or assign you an attorney, okay, when you do not want one. And here's the thing, guys. When you have an attorney, you are submitting to the jurisdiction of the court, state and a court. Attorneys never bring up jurisdiction, by the way, okay? All right, judge or fake judge surrogates are supposed to remain impartial, but under 48 U.S.C. 654, subsection 7, they cannot do so. All right, they are not. This is a mistake here. Apologize. By the way, I did a video 2 nights ago because I haven't done a video in a month. I was so freaking rusty. I made a shit video and I made so many mistakes, and I apologize. But this stuff takes a lot of time to put together, and I want it to be right. All right. Under common law, judges are supposed to be, they're called magistrates by the way, in common law, are independent of the court, and the jury issues a judgment. That's the point I'm trying to make before. All right. Fake judge surrogates also quorum non judice, which is means person before a person, not a judge, cannot yield a judgment because they are persons, not a judge, and therefore judicial authority was not present. Also, you're supposed to have other sovereigns around. You know what the other sovereigns are? Your peers. Okay? The other sovereigns are your peers. If you do not have your peers around you, it's not a lawful proceeding. You know who else are the sovereigns? Witnesses. So right away, they got you in a room for this nonsense. And how many of you have brought people with you and they won't let them come in? That a lot of states, like New York, is notorious. They're in a little closet. Some of them, like some of the support magistrates who make a lot of money for them, they give them the courtroom to give the appearance, the prop that you're participating in a judicial proceeding when you're really not. It's all fake. All right, so just read this right here. This is McIntyre versus Machinery. It's a New Jersey case that went to the Supreme Court, and as recently as 2011, Justice Scalia from the 1990 case, Burnham versus Superior Court, said, meaning in effect, quorum non judice for a person, not a judge, meaning in effect that the proceeding in question was not a judicial proceeding because lawful judicial authority was not present and could therefore not yield a judgment. How many of you out there have support orders by these fake judges? They're void. They're void. The hard part is getting the courts to acknowledge that. Okay, so here's another thing. You're challenging them to be disqualified. You're going to file a motion to disqualify a judge or judge surrogate under 28 U.S.C. section 454 because of this reason right here. Because under 42 U.S.C. 654, the state plan for the child support, subsection 7, 45 CFR 302.34, 303.107, cooperative agreements and arrangements with appropriate courts, law enforcement, such as district attorneys and attorneys general. This is an agreement with the state and the federal government so they can receive federal money. That means they're not impartial. You understand? So, this is it right here. Including the entering into financial arrangements with such courts and officials in order to assure optimum results. It's an arrangement. It's a pre-existing agreement. They're not impartial. They have an incentive. That means that they're more likely going to prosecute you than find you not guilty. Or find you innocent. Well, you already are innocent, but to comply with your due process. That's the reason why I did a video or two ago where I told you guys to send to the clerk proof that the petitioner entered evidence of oh Christ Almighty, reasonable suspicion. Okay, I'll remember the word. I'm a little rusty. All right, so these are and I'm going to show you right here. See, this is all proof that they're not impartial. They all they're not disinterested. All right, the case laws out there say they're supposed to be impartial and disinterested. They're not supposed to know anything. They're just supposed to see the facts and the evidence before them, but we know they don't. So now this is another way of you recording that you are objecting and you're looking to disqualify the presiding officer. All right, I'm going to move along here because, all right, so just read this. All right, freeze this, read this. All right, the due process clause protects you from fake judges. What they're doing is they're imposing their will on you. That's the reason why you got to fight. And you got to file objections. And you got to hold your ground. And you're going to cite these cases. The due process clause protects an individual's right to be deprived of life, liberty, or property only by exercise of lawful power. In other words, they have to have jurisdiction. Lawful power is jurisdiction. The due process clause protects a person against having the government impose burdens upon him except in accordance with the valid laws of the land. What are valid laws of the land? Constitutional laws that are in accordance with the Constitution. Now see here, they're using the word power of sovereign. That means that there are sovereign people. You're allowed to say you're sovereign. All right? All right, jurisdiction is power to declare the law. So if they don't have jurisdiction, they can't declare the law. As a general rule, neither statute nor judicial decree may bind strangers to the state. Who are strangers to the state? People who don't live there, non-residents. Okay, Burnham versus Superior Court. That's the case I cited. That's the case I discovered 2 years ago, where we started challenging the support magistrates, the fake judges, you know, the friend of the court, the associate judge, magistrate, attorney general, you know, assistant. They're all not judicial people. So therefore, they cannot yield a judgment. A person may submit to a state's authority in a number of ways. There is, of course, explicit consent, meaning you are saying you are knowingly consenting. I understand my rights and I am consenting. Right there is an explicit consent. Presence within a state at the time of suit. So there is the thing. Guys, girls, if you do not live in that state, they cannot bring you, they cannot force you or subject you to legal process for child support. It's that simple. The only way they can make you is if they serve you while you're in the state. How many of you guys receive stuff in the mail from another state? They have no jurisdiction or they have no personal jurisdiction over you. Okay, so please read this. Again, any judgment not by peers is void unless there is a waiver of right to a trial by jury. This is the case, Murray's lessee. And again, this was cited again right here. 2011. Okay? Read this again. This is what I was saying before. I was reading this before. So I'm just showing you that this case right here, 1856, was cited again in 2011. And I know it was cited in 2015, but I'm just showing you that don't let them say, oh, that's an old case. They'll do anything they can to trick you. They will flat out lie to your face. Okay? Here's proof right here that you are entitled, even in civil matters. Don't let them pull that nonsense. Oh, it's only in criminal matters. That's not true. Okay? Right here. For any controversy of $20 or more, you're entitled to a trial by jury. And I've had my people do it, and I've yet to see a judge actually competently dispel this fact. They always use trickery. They always cite a state statute which is unconstitutional. That's the reason why they need your consent. And they do it by implying it. Here's another thing. Only paternity cases, because there is no money controversy. So what they do is they when you demand the trial by jury in these child support proceedings, they always say, oh, in child support we don't do trial by jury. Only in paternity. See, what they do is they'll take something this small, like paternity, and then they'll apply it for everything. They're notorious for doing that. Now you notice. No, that only applies to paternity cases because there's no monetary issue. Any issue, this is me acting like I'm you in court, any issue of $20 or more in controversy, I am entitled to a trial by jury. It's a fact. It hasn't changed. State Constitution shall remain inviolate. Okay? So read this. Again, this is information, right? This is for the obligation of contract clause. Please read this. Understand that you got to respond to your paperwork. Here's a key. If they do not respond, silence is equated with fraud where there is a legal or moral duty to speak. Well, right here, there's their legal authority to obligation to speak. So if they don't, that's fraud upon the court, and you can have a judgment vacated under Federal Rule 60B, subsection 3. So it's 60B3, Federal Rule 60B3. Okay? All right, so that's it. All right, I know it's a long video. I haven't done a video in a while. I think it's a pretty decent video. I gave you a lot of information. Okay, just understand if you need to reach out to me, my email is rick, RSCK0327 @me.com. For a very, very, very reasonable gift, you can receive my paperwork. Okay? All right, guys. Have a great day. I'll talk to you guys later.